If you're waiting for your U.S. green card or planning to apply in 2026, what I'm about to share could completely change your timeline. Major policy shifts are coming, and thousands of applicants might miss critical deadlines. Some changes could help you, others could delay you by years. Stay until the end. Your American dream depends on this. Welcome back to Immigration Fresh Updates, where we bring you the most important immigration news that affects your future. Today, we're talking about something urgent. Big changes coming to the U.S. green card process in 2026. Whether you're on an H-1B visa, waiting in the employment-based queue, applying through family sponsorship, or even considering the diversity visa lottery, these updates will impact you directly. We'll walk through 7 critical changes you need to know about, ranked from number 7 to number 1 based on urgency and impact. By the end of this video, you'll know exactly what to do, which deadlines to watch, and how to protect your application. Let's dive in. At number 7, we have a change that affects millions of hopeful immigrants worldwide. The diversity visa lottery registration window is getting shorter. Starting in 2026, the registration period, which used to run for about 30 to 35 days, will now be condensed to just 25 days. This might not sound like much, but think about it. If you miss that narrow window, you lose an entire year of opportunity. The diversity visa program has been a lifeline for people from countries with low immigration rates to the U.S. It's one of the few pathways that doesn't require a job offer or family sponsor. For many, it's the only realistic shot at a green card. But with political debates around immigration reform, the program faces constant scrutiny. Some lawmakers want to eliminate it altogether, while others want to tighten eligibility requirements. Here's what you need to do. Mark your calendar right now. The registration typically opens in early October and closes in early November. Set multiple reminders. Prepare your documents in advance. Passport-style photos, birth certificates, education records. Don't wait until the last week because technical issues on the government website are common, and if the system crashes on the final day, you're out of luck. The diversity visa is still one of the most beautiful opportunities America offers to the world. If you qualify, don't let a shortened timeline rob you of your chance. This is about your future, your family's future, and the dreams you've been holding on to. Stay alert, stay prepared. Coming in at number 6, we're seeing something that's quietly frustrating thousands of skilled workers. Employment-based green card interview backlogs are getting worse, and 2026 projections show delays extending by an additional 6 to 9 months in major consulates. If you're on an H-1B visa or you've already filed your I-485 adjustment of status, you know how agonizing the wait can be. You've done everything right, found a sponsor, passed labor certification, filed your petition, and now you're stuck in an interview queue that keeps getting longer. Consulates in countries like India, China, and the Philippines are overwhelmed. Staffing shortages, security clearance delays, and administrative slowdowns are creating bottlenecks. Here's the reality. If your priority date becomes current in 2026, don't expect a quick interview. Some applicants are waiting 12 to 18 months just to get an interview slot. And if there's even a minor issue with your documents, you could be sent back into the queue. What can you do? First, make sure every single document is perfect before submission. No missing signatures, no outdated medicals, no translation errors. Second, if you're eligible to adjust status within the U.S., do it. Domestic processing is generally faster than consular processing. Third, stay in touch with your attorney and respond immediately to any requests for evidence. Yes, the wait is hard. Yes, it tests your patience. But remember, you've already come so far. Don't let frustration make you careless now. Your green card is closer than you think. Stay focused, stay organized. At number 5, we have a change that directly impacts families. New income requirements for family-based green card sponsorships are being implemented in 2026, and they're stricter than before. If you're a U.S. citizen or green card holder sponsoring a spouse, parent, or child, you've always needed to prove you can financially support them by meeting the poverty guideline threshold. But starting in 2026, the required income level is increasing by approximately 15 to 20%, and the scrutiny on income documentation is tightening. Why does this matter? Because many sponsors, especially recent immigrants or those working part-time, are already close to the minimum threshold. A 20% increase could push them below the requirement, forcing them to find a joint sponsor. And finding someone willing to take on that legal responsibility isn't always easy. Here's what's changing. USCIS will now require more detailed proof of income, tax transcripts directly from the IRS, not just tax returns. They'll verify employment letters more carefully, and self-employed sponsors will face additional scrutiny. If your income fluctuates, you'll need to show at least 2 years of stable earnings. What should you do? If you're planning to sponsor a family member, start gathering financial documents now. If you're close to the income threshold, consider getting a joint sponsor lined up in advance. If you're self-employed, work with an accountant to ensure your tax filings clearly demonstrate adequate income. Family reunification is one of the most beautiful aspects of the American immigration system. Don't let financial documentation issues stand between you and your loved ones. Plan ahead, be thorough, and you'll get through this. Number 4 is critical for skilled workers. H-1B to green card transition timelines are extending significantly in 2026, especially for applicants from India and China. If you're working in the U.S. on an H-1B visa, your ultimate goal is probably a green card. But the pathway is getting longer. The employment-based green card categories, particularly EB2 and EB3, are experiencing record backlogs. For Indian nationals in the EB2 category, the wait time is now projected to exceed 50 years based on current visa availability. That's not a typo, 50 years. Why is this happening? Demand far exceeds the annual quota of green cards available for each country. Only about 7% of employment-based green cards can go to applicants from any single country, and India and China have the highest number of applicants. Here's the harsh truth. If you filed your I-140 petition recently, and you're from India or China, your priority date might not become current for decades under the current system. Meanwhile, you're stuck renewing your H-1B every 3 years, unable to change jobs freely, worried about layoffs, and watching your life on hold. But there's hope. Some applicants are exploring EB-1 extraordinary ability petitions if they qualify. Others are considering employment in less backlogged categories, or even immigration through family if they have U.S. citizen relatives. Some are looking at alternative countries like Canada or Australia while keeping their U.S. options open. What you must do: protect your H-1B status, keep your I-140 approved and portable, explore all category options, and stay informed about potential legislative reforms. Yes, the system is broken, and yes, it's unfair. But giving up isn't the answer. Stay strategic. Stay hopeful. At number 3, we have something that affects almost every green card applicant. Major USCIS fee increases are taking effect in 2026, and they're substantial. Filing for a green card has never been cheap, but the costs are about to jump significantly. The I-485 application fee, which is currently around $1,140 for most applicants, is expected to increase by 30 to 40%. Other related fees, biometrics, work authorization, travel documents, are also going up. For a family of 4 adjusting status together, you could be looking at an additional $2,000 to $3,000 in total costs compared to 2025. For many immigrant families, this is a huge financial burden. Why is this happening? USCIS is fee-funded, meaning it relies on application fees to operate. With processing times increasing and operational costs rising, the agency is raising fees to cover expenses. They argue it's necessary to improve service, though many applicants question whether service quality actually improves. Here's what you can do. If you're planning to file for adjustment of status or any green card-related application, consider filing before the fee increase takes effect. USCIS typically announces fee changes several months in advance, giving applicants a window to file under the old fee structure. Also, check if you qualify for fee waivers or reduced fees based on income. Not everyone knows these options exist, but they can save you hundreds or even thousands of dollars. Money shouldn't be the barrier between you and your American dream. Plan your finances carefully, explore all available options, And don't let fee increases discourage you. Your future is worth the investment. Number 2 is something you need to take very seriously. Public charge rule enforcement is intensifying in 2026, and it could lead to more green card denials if you're not prepared. The public charge rule allows immigration officers to deny green cards to applicants who are likely to become primarily dependent on government benefits. This has always been part of immigration law, but enforcement goes through cycles of being strict or lenient, depending on the administration. In 2026, we're entering a stricter enforcement phase. Officers will scrutinize your income, assets, education, health, and family size more carefully. If you've received certain public benefits, even legally, it could count against you. If your income is below 125% of the poverty guideline, you might be seen as a public charge risk. What benefits are they looking at? Cash assistance programs, long-term institutionalized care at government expense, and certain forms of Medicaid. Note that emergency medical assistance, disaster relief, and benefits received by your children usually don't count against you, but the rules are complex. Here's what you must do. Gather evidence of financial self-sufficiency, employment letters, bank statements, tax returns, assets, education credentials. If you've ever received public benefits, document exactly what you received and why, and be prepared to explain. Work with an immigration attorney to assess your public charge risk before filing. The public charge rule can feel invasive and unfair, especially if you're working hard and contributing to society. But the reality is, it's part of the process, and you need to address it head-on. Show them you're financially stable, show them you're self-sufficient, and you'll get through this. And now, number 1, the most urgent issue affecting green card applicants in 2026, temporary protected status and DACA uncertainty, is creating chaos for thousands of people trying to transition to permanent residency. If you're currently protected under TPS or DACA, you've been living in legal limbo, often for years or even decades. You work, pay taxes, raise families, and contribute to your communities. But your status is temporary, and it's always been vulnerable to political changes. In 2026, several TPS designations are up for renewal, and there's no guarantee they'll be extended. DACA, which has survived multiple legal challenges, remains under threat. If these protections end, and you don't have another pathway to a green card, you could face deportation. But here's the critical part. Some TPS and DACA holders do have green card pathways they don't know about. If you entered the U.S. legally and have a qualifying family relationship, you might be eligible for adjustment of status. If you have an approved I-140 through an employer, you might have options. Some recent policy changes have opened doors that were previously closed. What you must do right now: consult with an experienced immigration attorney to review your entire history. Don't assume you have no options. Explore every possibility. Family petitions, employment sponsorship, special programs, humanitarian relief. Some people have been living without status for years and then discovered they were eligible for adjustment all along. Time is running out for many of you. Political winds can change quickly, and programs that exist today might not exist in 6 months. If you're eligible for a green card pathway, start the process now. Don't wait for the perfect moment. It might never come. You've already shown incredible resilience by surviving in temporary status for so long. Now it's time to fight for permanence. Your life, your family, your future, they all depend on the actions you take right now. Comment below and let us know where you're watching from and which of these changes affects you the most. Are you waiting for your green card? Share your story with our community. These 7 changes are real, they're happening now, and they will affect your green card journey in 2026. But here's the truth. Knowledge is power, and action is everything. Don't let fear paralyze you. Don't let uncertainty stop you. Take control of your immigration journey today. Consult with professionals, gather your documents, meet your deadlines, and keep pushing forward. Your American dream is still possible. Which of these changes will you act on first? Let us know in the comments. And don't forget to subscribe to Immigration Fresh Updates for the latest news. We're here for you every step of the way.